The history of the Constitution is quite unique, as the actual first Constitution that we lived by in 1781 was the Articles of Confederation. Now, with the Articles of Confederation, the responsibilities of the government were divided among the states and the central government. Now, from the article that I found on FindLaw.com, you could say that the Articles of Confederation were kind of a loose confederation, but it made way to our current Constitution, so it was just as important. In May of 1787, the Constitutional Convention of Delegates came about. So this is where all the delegates came, they met up, they argued, they debated about how much power a state should actually receive. And also they decided that maybe a whole new document was needed rather than just fixing the Articles of Confederation. So with that, once all the delegates agreed, they finally came up with our first draft of our Constitution, and it was finally signed in on September 12th, 1787. From our textbook, Constitutional Law and the Criminal Justice System, we were able to find a very defined outline of what the Constitution really is. The first three articles describe the branches of government: the legislative, the executive, and the judicial, and it also goes along with the country's systems of checks and balances. These are very important as they explain the transitionary of power within the democracy, as they equally divided, they equally have to check on the balances of the power between each branch. In Article 4, it talks about any other provisions, either old ones from the Articles of Confederation or newly established ones. Article 5 outlines the amendment process, and in other words, it's how the Constitution may be amended. This was able to create an equal say throughout the whole country on what the amendments we should give or what the people want for their amendments. Lastly, Article 6 declares the Constitution is the supreme law of the land. There are two specific parts in the Constitution that talks about the limitations of the power of the government. So first, you got checks and balances. Now, these are the limitations between each branch of government: the legislative, the executive, and the judicial. So with checks and balances, each branch has the power to check the power of another branch and limit it, or say that it needs to be more empowered. The other way that the government's powers are limited is that there is a certain line between federal and state governments. They give the state the power to have their own government, but it's not only what the federal wants. The state can still say what they want for their specific state. From both our textbook and the whitehouse.gov website, I was able to find the specifics of each of the branches of the government. So the legislative branch, which is the House of Representatives and the Senate, make up Congress. They can enact legislation and declare war, confirm or reject any presidential appointments, and they have investigative powers. The executive branch is the President of the United States of America. He implements and enforces laws written by Congress, and he has the power to appoint heads of federal agencies. The judicial branch is elected by the president and confirmed by the Senate, and this is the Supreme Court. It is important because the Supreme Court has judicial review power within it, and it takes on the cases that concern all federal law. So that is the power and the necessity we get from the Supreme Law or the judicial branch.